Yeah. You go in.
That is. Okay, my daughter was currently 26, but every year she moved up, they said.
Who advertises
Yes, it is. Just the engineer.
Madam Chair, we'll jump right into it. This is a formal hearing of the Board of Supervisors of Carnarvon Township to consider a conditional use application of FB at Magnolia Green LLC related to the property at 2019 A Willow Glen Road in Morgantown, also known as the former Morgantown Airport property, comprised of two parcels, approximately 56.6 acres in size, located in the township's industrial office park IOP zoning district, which permits mixed-use residential developments by conditional use pursuant to ordinance number 325 of 2025. This application proposes a residential and commercial development consisting of a mix of single-family residential and townhomes, commercial uses along Main Street, also known as State Route 23. By way of brief explanation, again, this is a formal hearing where the applicant here tonight will be provided an opportunity for witnesses and evidence to demonstrate that it has complied with all of the requirements set forth in ordinance number 325. We have a court reporter who's sitting to my left, your right, is going to transcribe all the testimony verbatim. Because of that, we need to proceed in a more orderly fashion than the typical township meeting may occur. According to the agenda that we've provided, the applicant's going to go first, going to present witnesses. I don't know how many, normally that's 3 or 4 witnesses in most applications. They're going to be sworn in. The reason for that is the Board of Supervisors can only rely on facts that are presented to it under oath. After each witness is presented through examination by their attorney, board members will have an opportunity to follow up with any questions of their own. Any other parties that are recognized here this evening will also have an opportunity to cross-examine witnesses presented by the applicant. Once the applicant's case is completed, any other party, including township representatives, will have the opportunity to present any witnesses or evidence that they wish to present to the board as well. Once those parties are complete, then the applicant will have a case or opportunity to present any rebuttal testimony that will then conclude the evidentiary part of the hearing. At the conclusion of that, before the board takes official action in accordance with the Sunshine Act, members of the public can present comments to the board. And then the board will take action. The board usually runs until some point, 9 o'clock or so, at which point we'll stop for the evening. If we're not completed by 9 o'clock, we will continue the hearing to a second night. The board doesn't want to go too late in the evening. So there is a chance that there will not be a decision made tonight, but it'll go to a second night. There is a chance, even if we do complete testimony, that the board will want to take everything under advisement and reconvene at a later date to actually make a decision vote. The vote will occur in public at some point when the board is ready to make a decision. That will be followed by a written decision within 45 days of the conclusion of the evidentiary hearing. There is a right of any person or party who is affected by the application to intervene this evening and become a party to the proceeding. So as at this point in time, if there's anybody who lives in the vicinity of the subject party, for example, who wishes to become a party to the proceeding, to raise your hand, we'll ask for your name, address. For the record, I've gotten 2 forms so far. I'll ask you to complete a form so we have record of it. I've got 2 forms so far. Patricia Beaton, B-E-A-T-O-N, are you here? Great. At 6 Highcroft Drive. And I know applicant has no objection to you becoming a party to the proceedings, so there's no issue with Ms. Beaton becoming a party. Okay. We have Frank Aoto. Okay. A-I-U-T-O for the record. 70 McEwen Lane. Sir, why don't you stand up and McEwen, M-C, capital E-W-E-N Lane. That's Morgantown. I'm sorry, Elverson. Can you describe how close you are to the Morgantown Airport property?
My property butts right up to the side of the middle school, the final baseball fields at the, near the gold stack at Fire Hill.
Okay, can you see the airport property from your yard?
Yes, I can see the Walmart from my backyard.
Can you estimate in feet or yards how far your property is to the Morgantown Airport property?
4,000 feet, let's guess. There's part of the lawn that's between myself and the airport. And then, I can see it.
Okay, but you can see the airport field. Any questions from applicants' counsel? Okay, no objection. Is there any other member of the public who has not yet had a chance to complete a form but wishes to intervene and become a party to the proceedings? By becoming a party, you will have the right to cross-examine witnesses, present your own testimony, and it also preserves your right to appeal a decision that you deem to be adverse. If you do not become a party, you may arguably lose your right to appeal a decision that you don't like. Let the record reflect, we have no further requests to become a party. So, given that there are no objections, I would recommend the board make a motion to grant party status to Patricia Beaton, B-E-A-T-O-N, and Frank Aoto, A-I-U-T-O.
Second.
Second, all those in favor?
Aye.
The board marks a couple of exhibits just for legal housekeeping matters at the beginning of these proceedings. So I'd like to do that at this point as Exhibit B1, it's Board 1. We have a public notice that was prepared in response to the application. As Exhibit B2, we have an affidavit of posting prepared by Jeffrey Curlin that affirms and verifies that the subject property was posted along the frontage of Willow Glen Road and along the north side of Main Street and along the east side of Highcroft Drive in the vicinity of the recreation parking lot. Attached to the affidavit is both a map depicting where the postings occurred and photos of the actual postings. And then Exhibit B3 is a date of proof with the Reading Eagle, evidencing that the public notice was published in the Reading Eagle on April 14th and April 21st, as required by the municipality's planning code. So we'll mark and include those three exhibits in the record. We'll have applicant's counsel identify himself, and then we'll proceed straight to applicant's case at this time.
Good evening, my name is Chip Lawson, attorney with Bartlett Snyder. I'm here on behalf of FB at Magnolia Green LLC relative to the conditional use application. With me this evening is Gary McEwen, the real estate development coordinator for Burke's Homes, Aristides Otero from Wilkinson, and Eric Mounts from Traffic Planning and Design. I provided copies of 11 exhibits and packets that I left for each of you that we'll run through in turn. The conditional use process is a use that's permitted by right so long as the criteria set out in the zoning ordinance are satisfied. The township may impose reasonable conditions on any conditional use approval that it might grant. The grant of conditional use approval would allow the project to move forward with typical subdivision and land development planning process, including submission and review of preliminary plan and a final plan, and those submissions are reviewed consistent with the zoning ordinance and township solid. I'd like to call Gary McEwen as our first witness.
Gary McEwen, McEwen.
Gary, I'm going to give you a packet of exhibits and have you reference, identify them and reference them in turn for the record. Can you identify what we've marked as A1?
Yes, that is the application for conditional use.
Submitted by Wilkinson.
Correct.
And can you identify what's marked as Exhibit A2?
Yes, that would be plan sheets, number 102 and 202.
Can you identify what we've had marked as A3?
Yes, that's the substitution, novation, and indemnity agreement, which establishes, make sure I get this correct.
Does that establish the applicant's equitable?
Equitable ownership, it does. It's FB at Magnolia Green LLC, which is a Pennsylvania limited liability company.
And it references the agreement of sale for the property of 56.6 acres in total in Carnarvon Township.
Yes.
Jump out of order just a little. Can you identify Exhibit A7? Should be a letter from Kraft dated April 15, 2025.
Yes, it's a letter from Craft Municipal Group as a review letter regarding the conditional use application submitted for the planning commission meeting, which was scheduled on the 15th of April, 2025.
I'd like to run you through, and that was prepared by Scott Anderson.
That is correct.
So I'd like to run you through the comments from Mr. Anderson's letter and then the responses that you can offer with respect to each of those comments. We've taken sort of as a group. Item number 1 in the April 15 review letter references the township zoning ordinance with requirements for conditional use as set out in 500-79 A through G. Can you sort of walk through why you believe that our application complies with each of those requirements for the granting of a conditional use?
Okay, item 1A, the comment is to establish the proposed development is consistent with the spirit, purpose, and intent of the Carnarvon Township Comprehensive Plan. Carnarvon Township is part of the Southern Berks Joint Comp Plan. So that's what I looked at to make my comments. Per the comprehensive plan, the Southern Berks Joint Comp Plan, vision and goals, the Morgantown area will continue to serve active businesses and support higher density housing needs. Most new development should be served with public water and public sewer. And to further support this, Berks County Planning Commission provided a letter as part of the review for the text amendment dated July 25th, 2024, which indicates consistency with the future land use map of Berks County Comprehensive Plan 2030, the 2030 update.
So do you believe that the requirements set out in paragraph A1 have been satisfied with the application?
Yes, I do.
Can you address the response to paragraph 1B?
1B states, establish that the proposed change will not substantially injure or detract from the use of the neighborhood property or from the character of the neighborhood, and that the use of the property adjacent to the area included in the proposed change or plan is adequately safeguarded. The property is currently farmland with an abandoned grass airstrip. There were 2 airplane hangars, which only one small portion remains of the 2 hangars, and that is in the process of being demolished. The adjacent property to the north and northwest is bordered by single-family homes with some open space managed by a homeowners association. The property to the west, across Willow Glen Road, consists of a parking lot, manufacturing facility owned by Morgan Truck Body LLC. Farm fields are adjacent to the east and north. Adjacent to the south is Main Street, State Route 23. And there are 4 residential properties and a commercial business along Route 23 to the east of the property. The proposed plan will not detract from the neighborhood from the use because residential homes are proposed adjacent to all existing single-family homes. Commercial is proposed along Main Street, State Route 23, which is consistent with most of the uses along Main Street. Willow Glen Road is proposed to be relocated to exit onto Main Street through a signalized intersection, which will improve the safety compared to the current intersection of Willow Glen Road and Main Street. Road B, which is on our plan, that goes from the signalized intersection across from Lowe's up to the Highcroft community, and will create like a direct access to the intersection with Main Street, which will improve traffic flow and also improve the safety of the current intersection that I previously mentioned.
And can you provide testimony about the response to paragraph 1C?
1C states, establish that the proposed change will serve the best interests of the township, the convenience of the community, and public welfare. We believe it will serve to provide needed housing in the Morgantown area. It will also provide commercial uses desirable to the community. It will improve traffic safety with the relocation of Willow Glen Road, and it will provide more direct and safer access to Route 23 and commercial area through the signalized intersection.
Can you provide the response to paragraph or comment 1D?
1D states that establish that the proposed change will not preclude the logical, efficient, and economic extension of public services and facilities such as public utilities, police and fire protection, and public schools, and ensure adequate arrangements for situation in specific instances. Our response to that is the extension of public utilities will be efficient since sewer, water, electric, phone, cable, and natural gas are all adjacent to the proposed development. The proposed streets have been widened to provide better access of fire and police and EMS than was originally proposed. This was in direct response to comment letters provided by fire and police. And the proposed development is in close proximity of the elementary, the middle, and the high school of the Twin Valley School District.
And can you provide the response to comment 1E?
Says establish that the proposed conditional use relief is suitable for the proposed location to probable effects upon traffic patterns, emergency response, and ensure adequate access arrangements will be provided in order to protect roads from undue congestion and hazard. It's a little redundant, but our response to that is proposed conditional use is suitable for the proposed location because it connects Main Street with existing residential communities through a more efficient route and through a signalized intersection. This will also improve response time to the existing adjacent communities for the EMS responders. And new traffic patterns within the community will reduce potential hazards.
Can you identify Exhibit A4 and A5 for the record?
Yes, this is to establish the adequacy of sanitation and public safety provisions where applicable and require a certificate of adequacy of sewage and water facilities from the appropriate government health agency and authorities in any case required herein. My only comment to that is that we have serviceability letters from the sewer and the water authority, which will be provided, I believe, as an exhibit.
So can you identify that in that packet A4, a letter from the Carnarvon Township Authority dated April 2?
A4 is from the Carnarvon Township Authority, stated April 2nd, 2025, and it is a letter that states they have the capacity to serve this community, this proposed community.
Can you identify A5 for the record?
Yes, sir. A5 is a letter dated March 26, 2025 from the Carnarvon Township Municipal Sewer Authority, and it also states that based on the proposed number of units, there is capacity for sanitary sewer.
Maybe along with that, can you identify what we've had marked as A6?
Yes, sir. A6 is a letter from the Twin Valley School District Administration. It's not, I'm sorry, it's not a letter. It's a chart showing the enrollment numbers, their monthly enrollment numbers for the 2024-2025 school year, and the last count was April 3rd, 2025. And it states that the total district number of students is 2,844. There's also a second page, there's 3 pages. The second page is the Twin Valley School District student enrollment and building capacity information. This information was provided by a feasibility study completed by the Schrader Group Architecture out of Westchester, dated December 25th, 2021. it states that the building capacity total is 4,000, of all buildings, it's 4,279 students. And as of January 23rd, not 25, 23rd, 2023, the enrollment at that time was 3,013 students, which created an unused capacity of 1,266 students. Basically, the buildings are underutilized by about 30%. And if you recall, the previous page, the student population is 2844. So that's almost 200 students less than 2023. And then page 3 is a comparison of 2022-2023 school year. As of the same time, April 3rd, it was 3,004 students. So there is a declining enrollment in the Twin Valley School District.
And do those documents indicate inadequacy of capacity for the proposed development?
Yes, they do.
You provide a response to comment 1G.
Of the April 15th letter?
Yes. Is it fair to say that 1G basically references the municipality's planning code provision for conditional uses and allows the governing body to apply reasonable conditions to any grant of an approval?
That is a fair explanation of what is in section 109.13.2 of the municipal planning code, and I do not have any further comments on the MPC, the municipal planning code.
I'd like to finish with this line of questioning for Mr. McEwen. I'd like to be able to recall him at some later point, if his testimony would be helpful to clarify points that regarding the plan submission or any other issues that might not be addressed by the other witnesses we've got.
That's fine. Depending on who the appropriate witnesses are, maybe some of the board's questions, the board may ask that he be available in case some of their questions need to be answered by him as well.
Okay. I don't think Mr. McEwen's going anywhere. You can certainly feel free to ask him any questions about what he specified to so far. And maybe if it relates to specific issues about the plan or traffic issues and the like, might be better to have our other witnesses testify to those points and
Commitments, for example, commitments the developer may be willing to make or not make that consultants may not be willing to or able to address, for example.
certainly. So I'll finish with my direct if there's any cross questions or the like from Mr. McEwen.
There's questions on improvements like sidewalks and things. Would that be more appropriately addressed to engineers?
Well, maybe we just get to those questions now, and then we can get direct testimony if somebody else has any further enlightenment on the issue. So, yeah,
I think we should have some sidewalks along 23 in front of that. Witnesses there. Hi, I'm Paul White, the senior. Hi, I'm Paul White, the senior. I'm looking at the drawing, and I would like to have a comment. Looking at the drawing, everybody hear me now? Looking at your drawing, it seems like there's sidewalks on 23 in front of all the new commercial businesses.
That is correct. The plan is not showing any sidewalk. We had some discussion at the planning commission. There was no recommendation from the planning commission from our standpoint, if you'd like sidewalk along the front of those buildings, that, the commercial area, we'd be okay with that. I'm not sure how far you wanna go. Do you wanna cross, do you wanna go across the bridge? Those details can be worked out. But if
Well, I
you
think,
guys want sidewalk, we'd be willing to put sidewalk in.
I think it has to be worked out because of with the turnpike, putting a new bridge in there is gonna really mess things up around here, so.
We'd be open to put sidewalk along the frontage of Route 23.
Okay, very good. Thank you.
Okay, so I had one thing, Sandy Steyer. One of the thing for the school district, you have December 25th, 2021 is when this feasibility was done.
That's correct.
So if it's done in 21, how do we have 23 enrollment?
Okay, so the feasibility study was done by an architect, went through all the buildings to determine capacity. All the other things are actual enrollments that are tracked by the district.
And then what about all the new development that happened? Didn't Honeybrook have a huge development? None of those are counted in here? I mean,
This is actual student count, so that's live, what the
Right, I'm
student
just
count
saying.
is.
hasn't it increased since then?
The feasibility study was not done to look at the projections, because at that time they wouldn't have been there. It was done to determine what the capacity is. Next year, the district's enrollment is gonna drop by 65 more students, so it'll be under 2,800 students. And I know there's some developments there, but the numbers are what the numbers are, and some of those developments, I know the one big one is almost finished.
Okay.
So to answer your question, it doesn't make sense, but these are the actual counts. The feasibility study would be the same today as it was then, because none of the buildings have changed.
And the student sizes, I just find it hard to believe out of all those developments, we didn't have an influx of students coming in that would have increased these figures for 24.
I completely agree with you, but there is a declining, the student population across the country is declining. There are pockets where it's growing, but if you look at the trends, it's a downward trend. Doesn't make sense, I agree with you, but, they're the numbers they passed on.
Jump in with some of the logistics of the plan and how you intend to proceed. And so to begin with, the residential component of the plan is to the rear, your commercial uses are along the front. Your intention is to apply ultimately for a land development and subdivision plan. Are you intending to phase any aspect of this plan, or would this be one unified plan for all the commercial and residential uses?
The first thing, well, we probably will look at phasing the residential part of it. The first phase that we're looking at doing would be the Willow Glen Road extension and the traffic light, that would be Road B, where it enters from across from Lowe's, and the commercial and the townhomes, and at least what's along Road B that goes up to Highcroft. And maybe some of that, a little bit depends on where the utilities, how the utilities run, how the sewer and water runs. But, Willow Glen Road for sure would be in the very beginning of it. The commercial would also be in the beginning, because I believe, the timing of this, the commercial folks would like to get started as soon as they can get in there and get their approvals. And then the townhomes, it's kind of hard to phase the townhomes, because it's a loop street, so if you go halfway in, there's not a second way out. So look, that's our townhomes at this point. The commercial, Willow Glen Road, the intersection, Road B, and probably Road C, and I think it's Road C, Road B, I can't see it from here. So Road B and Road C, which would connect And then depending on how the utilities go, we may pick up road D and road E. So to answer your question, yes, the single family, residential portion of it, but the townhomes, Willow Glen Road and commercial would be in phase one.
Okay, and I think that's the key, and not having spoken with the board about it yet, but I think I know where the board stands. My guess would be that they'd like to see the commercial front-loaded in the development to be assured that the residential doesn't come and the commercial never comes. But your testimony here would be that the commercial would be part of phase one.
That is correct.
Okay, so you would have no problem with that as a condition of approval here, that however many phases that you have or structure this, that as long as commercial is part of the phase one.
I believe phase one?
Yes.
Okay.
Okay. And then with regard to the trail system, you've got the public trail that starts at High Croft and meanders around and through to along Road A, essentially. Is that intended to be a privately maintained trail of the HOA? Or is that intended in your mind to be a trail to be dedicated to the township?
The intention was it would be maintained by the HOA, but I believe the documents of the HOA could be such that it could be available to the public, maintained by the HOA. We could put that in the documents if that was what you would prefer. The thought of that trail, just to give you a little bit of background, is to have a walking area, I believe it's 8 feet wide, along Willow Glen Road, but not sidewalk, where sidewalk would be right up against Willow Glen Road. We kind of wanted it off Willow Glen Road from a safety concern. And then when it gets to the area where it's between the single families and the commercial, the thought was to elevate that so we can have some planning on either side to screen the commercial area from the residential. So it would not be 4 inches above the curb like regular sidewalk would be. And again, you want it off of Willow Glen Road, a little bit wider and a little bit safer.
Okay, and I see the point there, but the bottom line would be that repair, maintenance, snow ice removal would be on the HOA for that trail. It wouldn't be something the township would become responsible for.
I believe that we could put that in the association documents.
Okay, and would it be a trail that would be ADA compliant in your view? Members of the public will be accessing it, in particular to get to some of the commercial uses.
I don't know if we've looked at profiles enough to be able to answer that question. Obviously, the crossings, that crosses Road C, D, and E, and then where they cross into the commercial area, they would be ADA compliant. I can't honestly say that the area of all the trail between the streets, between Road C, D, and E, would be ADA compliant. That's something that maybe Aristides can answer when he gets up here.
Okay. Ultimately, we'll get to traffic, but I know that in concept over the year or 2 or 3 that this has been discussed at times, you recognize the need to improve signalization and timing along Main Street, and that's been a need recognized by the township, and at one point you had offered to help in that endeavor with a $70,000 contribution. Is that something that you're still offering through this application?
Yes, that offer still stands. And can be a condition.
The rest of my questions can be addressed by the engineers. Thank you, sir. Mr. Anderson?
There's no other questions, I'd say that. Scott?
Just one question to add, Scott Anderson, Craft Municipal Group. Similar to the questions about the ADA and the layout there, just generally speaking, I know the crossings are shown at the most of the new intersections. And simply put, I think my question is, would the design be, or would you be open to any of the alterations that would place those crossings, possible stops at those intersections to just ensure that it's at the safest design location for pedestrians and motorists? And I ask this simply because we reviewed this for the conditional use application, but not the design specifically, in case those are altered for other reasons.
I would say probably, but, I would like to defer to when a traffic engineer gets up to the stand. I would say yes, unless there's something traffic-wise it's gonna create a problem. You're aware that we added a third lane between the commercial and the residential to avoid conflicts, turning into the commercial, turning into the residential. I'd rather Eric answer that question. We wouldn't have a problem with it unless there's some sort of a traffic flow. Your residents might have more of a concern about those folks coming around Old Glen Road, but that's, I don't know, Eric can address it from a traffic standpoint, but from a cost standpoint, or wouldn't have a problem with it.
I do have one other traffic question. You're probably already aware of this, but at the Crossings Boulevard, that traffic signal that exists is subject to a traffic signal maintenance agreement with the user that put it in Wolfson. And that agreement requires any additional users at that intersection to share in the maintenance costs. It'll offset Wolfson's contribution by the additional users. You wouldn't have an objection pursuant to that existing agreement to share.
I would like to see the agreement first, but, I don't.
In theory or concept, I think the maintenance cost of that is now splitting, it would be splitting the roughly probably $1,000 or so maintenance cost with Wolfson.
$1,000 a year, $1,000 a month.
I think it's
It varies, like, yeah,
1,500.
probably a fair guess.
1,500. It's in that neighborhood. We would get the agreement.
Okay. I'd like to make a final decision on that after we read the agreement.
Understood.
And then, one more thing. So then, since we're talking about that light that's going in the road there, you're okay with having a fence put up for those young kids that live in that house? Make sure they're not getting out on that new road that's going in at that light?
I'm not opposed to putting a fence along their property.
And then you still have the trees and the berm, whatever around the property?
Yeah, they have a pretty good row of trees there now, so, if we need to add to it, add a fence to it, yeah, I understand. Also, we haven't talked to them yet, but we'd like to talk to them about, we committed to the sewer authority that we would provide sewer for the properties, those 4 properties. And, also maybe give them a rear access if it's feasible, so they could get out onto, the road F, so they would have an alternative access to the property. But yeah, we do not have a problem installing a fence. I'm glad you brought that up because we would have not thought about that.
Do either of our two parties have questions for Mr. McHugh? No. Speak,
Me?
yes. Questions for Mr.
Yeah,
McHugh?
I was going to read this later, but I do have a question. How many hens?
114 single families and 84 townhomes.
This won't cause the traffic.
I'm sorry, can you speak up and?
This will not cause a traffic problem?
I'm not a traffic expert. We do have a traffic expert here. I would prefer that he would answer that question. He can go into a lot more detail on, traffic mitigation. Okay?
Yeah, I have nothing against it.
That's okay.
Gotta bring up questions on this planet longer than anybody in this room.
Okay, thank you, Mr. Halls. I guess we're ready for your next witness. Okay.
So I'd like to call Elizabeth Zotero, as our next witness.
I would prefer to know.
Okay. You sworn in, Mr. Zotero.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, and nothing but it.
I do.
Please state your name for the record.
Aristides Otero?
Can you please spell it for me?
I can. First name is Aristides, Aristides, D is a dog. Last name is Otero, Otero.
Right, first, unless Gary got exhibits mixed up, did you find exhibit 8N in the spec that should be received? You testified before this board previously,
Correct.
and your CV sets out your employment. Can you state what your professional licensing in Pennsylvania?
So, I have a degree in landscape architecture. I've been practicing, land development, landscape architecture since 1998. Currently employed by Wilkinson Design Group out of Pottstown, PA. My former employer was Stackhouse Spencer, which was acquired by Wilkinson. And I'm a senior project manager.
And are you familiar with the conditional use application? It's A1?
Yes, we prepared it.
Okay. And can you recognize A2, the plan sheets?
Correct, plans 1, 2, and 202, which are the conditional use application layout plans.
I might just get everything for a reference and then we can go back and forth. Did you prepare a revised set of plans that we marked as Exhibit A11?
Yes,
And were those plans to address a comment review letter that you received from Mr. Anderson dated April 15th?
correct, yeah. A11 responds to comments from draft municipal groups letter dated April 15th in regards to landscaping.
So as just a general plan overview, can you describe the proposed development as it, in terms of acreage, the number of units, the commercial streets.
Yes. Sure, so the proposed plan, as already stated, is the former, or now defunct, Morgantown Airport. It's proposed to be a mixed use. First, the property is just under 57 acres. And per the ordinance 325, as adopted by the township this year, it permits the mixed use proposed as a conditional use. The mixed use contains, as presented, contains 114 single-family dwellings, 84 townhomes, and then a 7.59 acre parcel fronting Route 23 for commercial.
Just, and then 7.59 acres for commercial, that's obviously more than the minimum 10% required for commercial.
Correct. Within the plan is a network of streets, as already discussed. There are two streets. Road A, which parallels Main Street, is actually an extension and realignment of Willow Glen to resolve the, I'll say, dangerous intersection with Willow Glen and Route 23, and also reflects proposed improvements to the bridge with the turnpike. The other dedicated road is Road B, which would be north of the existing traffic signal to the development across to the south and extend up to the Hunter Hill Road. Those two roads are proposed to be dedicated. The remaining roads within the development are proposed to be private and serve residential facilities.
Does the plan as presented meet the ordinance requirements regarding density?
Correct. The ordinance requirements in 325 are, I think, a maximum of 6 dwelling units per acre. We're under that. I think many moons ago, a previous plan had it at 6 through conversations. We actually increased lot size of a number of these proposed single-family lots, reduced our overall single-family units, and so we're subsequently between 4 and 5 dwelling units per acre.
And there are also additional increases in parking spaces like for the townhome community area.
Correct.
And can you describe the percentage mix of single-family detached and townhomes as it relates to the requirements in the ordinance?
Sure. So the mix of single-family and townhouse requirement, as shown on this plan, is compliant with a total of about 57.58% being single-family and 42.42 as townhomes.
And the ordinance requires that at least 50% be single-family homes?
Correct.
Can you describe the open space areas depicted on the plan, and then also reference active rec areas?
Sure. As part of the requirements, not only for this, but with the PRD, we needed a 30% open space across the entire development. We show a number of these open space areas throughout the plan. We've depicted several locations for potential active recreation, the actual final design of which, whether or not those are something like a basketball court, volleyball courts, that type of stuff is yet to be determined. But as those areas are refined, we will, currently, I think the comment indicated that we were above, minimum, maximum of active rec of the open space is 25 to 35%. And I think the way it's currently depicted on this plan slightly exceeds that percent, but we're still working through what actual elements are associated with the active rec, and we can certainly show that would be compliant with between the minimum 25 and the maximum 35% of the 30% overall open space would be active rec.
So maybe just trying to break that down into a couple pieces.
Yeah.
The ordinance requirement is to have 30% of open space
For the total tract.
for the total tract, how many, what percentage do we show currently? Is it approximately 33%?
I was just gonna say, we're like 33%, I don't know the exact 33 point something, but.
Okay, so as we get into the review letter, as it relates to questions about shown utilities and roadways and the like, we're already over 30%, so if there are any adjustments required, so long as we don't go under 30%, we can make those adjustments.
Yes.
And then I think what you described was that of that 30%, no more than 25%, no less than 25%, no more than 35% can be active rec area, and I think the plan shows 50% active rec. So we basically included active rec playgrounds in a couple of areas that it could be an either or type scenario. And we also showed all the open space that the walking trail passed through, that those all be counted as a whole within that active rec, rather than just the distance along either side of that trail.
Correct.
So we can make adjustments to get the active rec area within the prescribed limits.
Yes.
In the packet there, you should have a review letter from Mr. Anderson, A7. I'd like to run through responses to those comments, if you could. Starting with, so Mr. Kuhn addressed the items in paragraph 1. Could you just reiterate the comment for item number 2, and then what response you can offer to that comment?
Sure. Comment number 2 on the April 15th, 2025 craft review letter indicates utilities are not shown on the plan provided. Any utility easement or right-of-way must be excluded from open space according to section 628D3C. Open space area A2 must clarify existing stormwater and drainage easements have been excluded from the open space area. So I'll start with existing utilities are shown on the plans. We are still working through the pipe networks and if there are drainage swales that are needed. So that is still in progress and will be placed on plans during the full engineering and land development aspect. The conceptual areas for the proposed storm basins and storm facilities have been accounted for in our open space calcs. In regards to open space area A2, I believe that is in the northwest corner, just south of the Highcroft Road development. There is an existing drainage / stormwater easement up there that has been accounted for. However, we're actually looking at kind of revising that area to become more of a storm management facility, so that would be more of a basin type thing. If at this point we're looking at an MRC type basin, because I don't believe we had infiltration rates that would permit an infiltration facility. But as that basin is finalized and its exact limits and slopes, top of berm, all that kind of stuff are identified, we will show compliance with the open space calcs and exclusion or percentage thereof dedicated to the stormwater management facilities.
Can you restate the comment number 3 and then the responses you can offer to that comment?
Sure. Comment number 3, common open space cannot include front, rear, and or side yards of an individual building in accordance with section 628D3F. The open space is not clearly defined around the townhouse buildings, and it cannot be verified if the yards are excluded. Absolutely. I think when these plans were previously submitted under a different process, our plans indicated a boundary around the townhouse clusters. I think our line work got turned off, but on these particular plans, but these calculations exclude those areas in regards to what's considered open space. So,
just to reiterate there, so the required setbacks are depicted on the plan, but the boxes
correct.
for the area for each of those townhome units isn't called out, but it was excluded from the calculation.
Correct.
So again, that's an item on the, preliminary plan that we could put that toggle.
Turn it way back on. Yeah.
Okay, so, can you do the same for item number 4?
Sure. Common floor, maximum density calculation shall exclude areas devoted to non-residential use, including stormwater per section 628E. The plans do not appear to include any of the stormwater management areas in the non-residential areas. The density calculations need to better clarify this required exclusion. Excuse me. So the areas to show in the plans are shown to handle the requirements for township and DEP for the residential component of this development at maximum impervious allowed per lot. So while a particular home on any of these lots may be a particular size, that's not the maximum impervious permitted per lot. Our stormwater facilities are designed to permit, whatever the percentage was, I forget, per lot of impervious coverage.
So the footprint of the proposed homes is less than the maximum impervious and allows room for a shed or a deck or the like.
Correct. That feature proofs if a homeowner comes in and wants to add, a patio or a shed that's compliant, obviously that would come before you as a permit. But the stormwater systems themselves account for that potential addition by homeowners. In regards to the commercial, that is being developed, and their developer has an engineer that has indicated that the required stormwater management associated with the commercial aspects will be handled directly on the commercial lot themselves, more than likely based on the current layout underground facilities.
So again, just to clarify, we're not proposing any stormwater capacity from the commercial lot to be shed onto the residential portion of the project.
Not at this point, no.
So on that point, so that we're clear on that, will a plan note be added to that effect, or can, I think we had to memorialize that?
The commercial,
Lots will be responsible for stormwater management, and that it will be addressed in their lots.
I think the only.
How do we know that, in other words, other than the testimony that was just given?
Let me just try to respond to that. I think to say that the stormwater on the commercial property will be addressed on the commercial property would be better, because they may elect to have some community type facility. I don't know if it would be leased parcels, so we wouldn't necessarily require it to be like per lot, but again, commercial lots would be responsible for addressing the stormwater for that commercial property.
I think we're amenable to adding in the actual wording. We can coordinate with the township on, ensure you're satisfied.
Can you address comment 5 and then response to that comment?
Sure. Comment 5, a comprehensive community landscape design plan is required by section 628I1C. Completely understood. This was a requirement that was shown during the previous plan process. The plan has matured and been revised to meet additional township requests for larger lot sizes, widening of roads, increase in the number or percentage of single-family lots. This will be revised to show compliance with township requirements. We did, and Mr. Hawes, if you want to reference what I believe, yeah. Exhibit A11 is basically the conditional use plans as submitted during our application process with the landscaping layers that had been turned off toggled on.
Right, so that's, again, that's projected on the screen. And what we're addressing is the landscape features are toggled on in that exhibit along the perimeter of the property, along Willow Glen, proposed Road A.
Correct. That plan shows, street trees, it shows buffers between commercial and residential, between our project and adjoining property owners, as well as along the proposed, I'll call it community path.
Can you address comment 6 in the response?
For comment 6, Road A, to be dedicated, proposes street width of 39 feet. Although this meets the minimum 33 feet width required by section 628I1D, sidewalk is not proposed, but was included at the time ordinance 325 was reviewed. We touched on this a little bit, and was discussed a little further with the township at the April 2025 Planning Commission meeting. As was indicated earlier, a central turning lane along Road A, the extension of Willow Glen, was added between the residential and commercial. And we do show the 8-foot wide walking path on the north side of Road A, which permits space for pedestrian safety, as well as not having the sidewalk right up against the road provides for safety and additional room for visual buffering and screening with landscaping and berms.
So, I didn't swear or affirm to tell the truth, no truth, but I would offer that with respect to showing the proposed walking path through the property, essentially to serve as a sidewalk, the functional equivalent of the sidewalk, we would intend to apply for a waiver under the Saldo provision, I think it's 50212, that's incorporated into the zoning ordinance. If it was determined that rather than a waiver, because the provision is referenced, Saldo provision is referenced in the zoning ordinance, that we need a variance, then, then we'd seek a variance if that's the appropriate issue. But again, along Road A, we're not showing proposed sidewalk on both sides instead of 2 4-foot sidewalks. For some of the reasons that Gary alluded to in his testimony, we're proposing an 8-foot wide walking path along Road A, and then other portions of the property. And similarly, we're requesting sidewalk on one side for Road B. Again, we believe that a waiver would be the appropriate process to a waiver under 50212 of the Saldo. But if it's a variance that we need, because it's again referenced in ordinance 625, we would go that process. So I think we're up to 7.
Sure, 7 kind of reiterates the need for sidewalk on both sides along Road A. B, sidewalk also be required along Main Street, State Route 23, Highcroft Drive, and Road H. The plans as shown would require relief from the zoning hearing board. As Mr. Hawes indicated, we would likely seek waivers for this requirement along the proposed to be dedicated roads A and B, and H. As discussed earlier, the township indicated the desire to have sidewalks along Main Street. It seemed like that is an amenable position from our clients, so we wouldn't be looking for relief at that point.
I think on that point, it's the goal to have that sidewalk connect to the sidewalk that the Turnpike Commission is going to install at the bridge. So are you familiar with the Turnpike Commission's plan? And do you see any issue with being able to connect to the sidewalk that the Commission's going to be installing?
I don't see any issues. I know we've been in communication with both the Turnpike Commission and PennDOT and kind of sharing back and forth plans. I think at this point, they're still working on their development exactly. But we would certainly coordinate to be able to tie into whatever pedestrian access they would provide or propose.
And then getting back to the trail itself, if the trail is going to be used by the public, what's your position with regard to making it ADA compliant?
Sure. There isn't a great deal of topography across the site. We're still working through the grading elements, but I don't see any issue with making that trail ADA compliant. And as stated earlier, you know, certainly any crossings of streets would need to be ADA compliant. We can apply that.
We're at item 8. Review letter?
Item 8.
Yep.
Section 628J1 allows for open space to be dedicated to the township. If the township would not want this to be dedicated, a condition could be established to eliminate the possibility of dedicating open space to the township. That's common, certainly acknowledged. I'm not sure what the township wishes to do at this point, so.
And if it's not going to be dedicated to the township, I'm assuming that your plan would be to have the HOA maintain the open space in accordance with an open space management plan that would be submitted and approved by the township.
I'll defer to Mr. McKeown, but yes.
No, he's not even the affirmative.
He was previously sworn, he says yes. Did you have any follow-up there? Okay, sorry. Can you address comment 9?
Correct, yeah. So comment 9, the township may want to consider establishing the condition that all trees planted for the community landscape design plan, section 628K, are not within the right-of-way of any street to be dedicated. If that's the wish of the township, we have no qualms with shifting the proposed street trees outside of the proposed to be dedicated right-of-ways.
Yeah, I think there's already an ordinance in place that prohibits that. And if the board has any concerns or suggestions on where landscaping should be located or should not be located, you would probably want to have that discussion. And in particular, if the other parties have any concerns with regard to where landscaping or buffering should be located or not located, with regard to where their homes may be located, this would be an opportunity this evening to address that with regard to the landscape plan. Continue.
And just, I'm sure we'd be amenable to, you know, input about that, and then, again, as we work through, assuming we get a favorable decision on the conditional use, as we work through the preliminary plan, final plan, we can incorporate any of those details into that community landscape plan.
Yeah, I see right off the bat that there's no landscape along the frontage of Main Street in front of the commercial uses. I don't want to assume the reason why, but can you address your approach to that?
Well, I know that at the time of the development of the landscape plan, the commercial lots was still in flux, as is the PennDOT requirements for the HOP work along Route 23 and our access points. I believe, perhaps you can correct me, as part of the commercial development, they would be looking at whatever landscaping requirements would be required along Route 23, specifically in front of the commercial aspect. Certainly, we have to be amenable or adhere to any kind of clear site triangles or site distance things that the township and or PennDOT would require. And as I said, those are still kind of in coordination effort with PennDOT. Maybe Mr. Mounts can tie in with it, but no qualms with adding landscaping.
I think that Mr. McEwen indicated he has input on that issue, if you don't mind, taking a little sequence.
City's covered it. He said, wouldn't be opposed to landscaping along Route 23, as long as it's of a low type, so it doesn't affect sight distance. And also, there's probably a visibility concern with the establishments that are in there as well. So the answer is not opposed to landscaping, just like to have some conditions that it would be lower type, not blocking the businesses and not blocking the sight distance.
On the upper side, the north side of Willow Glen Road, relocate, you have a landscaping buffer berm.
Yes.
And you had mentioned about making that ADA compliant. How are you gonna do that with a buffer, like a berm?
Well, I'm not looking at making the trail go up and down. It's more of you're walking and there might be an elevated berm. You know, if I'm walking from west to east and the commercial's on my right, there might be a berm there. So that if you're walking, you know, with your kids or your dog, there is not just a visual buffer, but also a physical buffer between the path and the street. That's not to say it's gonna be dead flat. As we grade this, there might be some undulations, but ADA compliant.
And my other question was earlier, your stormwater calculations, you're doing the residential separate from the commercial. When you were figuring in your calculations for your open spaces, did that include the commercial or not? The open space calculations?
Yeah, no, it's 30% of the
Of the entire property, or just the residential?
I believe it was the entire property.
That's all I have.
You have a question on the landscaping?
Yes,
Would mind taking it now, since we're on the subject?
that's what I was.
Yeah, let's just do it.
Uh,
Name, again, name just for the record again.
Frank Ayuda, 70 McEwen Lane. The reason aesthetics are important to myself and probably 4 or 5 of my neighbors is we border. I'm assuming this is the airport and the farm is still going to be there, right? The schools are here. I'm next to the school and I have 4 or 5 neighbors that border that area. We are at elevation. So when we look down, that's why I can see as far as I said that I can see. So we have no light filtering, we have no light blockage at that point. The woods are thinning from age, things like that. So that's my concern. That's why I'm asking about landscaping. Are the commercial businesses like the ones across the way, are they 1 story? This is my concern.
That I don't know, but I would assume.
You have Barry address that?
Yeah, that's important, and I think it triggers a couple of things. So one, I'll restate the question, I think. But Frank can correct me if I'm wrong. So what is the approach or strategy that you could use to address the change in elevation and address the goal of buffering in a situation like this? Is there a strategy that you can use? It's a specific type of landscaping to satisfy their concerns, 1, and then 2, with regard to lighting. We don't have a lighting plan presented here tonight, but can you describe some of the proposed lighting that you anticipate with regard to the neighborhood, both residential? Is there street lighting proposed in conjunction with the sidewalks, and then with regard to commercial too? So it's a compound question, and maybe Frank will then have some follow-ups.
And I mean, if you drive down 23, and as you're passing the Lowe's and Walmart on your left, you look at the schools to the left. You'll see the low grade, and then you'll see the rise, and you'll see the houses. That's us.
Yeah.
And that's why I'm asking you the question.
So I guess I'll start with the landscaping ability to buffer from a higher vantage point. I don't know that there is a way to fully buffer from your vantage point, because no matter what, you're gonna be looking down. That being said, there is an area along the rear of the proposed residential lots that would permit us to facilitate any kind of buffer that the township would like as far as vegetative buffers. Again, I don't know that even at a fully mature height that it's gonna completely block your view of the valley. You got a great vantage point.
And that's an effort to address the concern with
Can I go back on record? So, first of all, where you're depicting your houses is a little bit deceiving because you're probably at the top of that, tripod, which is about where your houses are. Your elevation is significantly higher. I don't believe there's anything we can do in our development that's gonna shield your view. The only thing we could do is possibly look at adding some landscaping on your property to block your view, or to mitigate the view that you could be impacted. You're gonna be looking at, all the way across the fields, the rear of the homes, there will be streetlights. I believe there is, kind of a streetlight recommendation that the township has that we would be complying with. As far as the commercial area, I would imagine that their lights are gonna be for their property with very little light pollution leaving their property. Kind of like if you look at the athletic fields now at the school, the lights changed. They put LEDs, which are directional, far less light pollution than what there was before. So from the commercial side, I believe that's probably your biggest concern of light pollution and with new technology. That I believe can be mitigated. But I don't believe there's anything we can do on our property that can block the view.
I understand. I think this is.
Sorry, I can't hear you.
Just to give them, I'm showing them a picture of the property, just to give them an idea. This is, you asked if we can see the airport, here's the airport. These are what we see, and that's where everything is going to be. And that's just to kind of give you an idea.
What I'll tell you is that, we'd be happy to come out there with you and try and look at something that can mitigate, what your concerns are.
That would be appreciated.
Okay. Thank you.
Thank you.
If you could address the lighting issue.
Yeah, I think Gary touched down on that. We have not done a lighting plan design at this point. It has indicated the required street lighting through the residential aspect would meet township requirements. I know we typically try to specify dark sky compliant, which is a full cutoff street light fixture, so that you don't have upward glare to pollute the sky, and the full cutoff also assists with mitigation for spill horizontally.
Okay, so that would be the start, and that would be something that we could impose as a condition on the commercial uses, so that light's not exceeding their parcels in the front. So it's full cutoff at the commercial uses.
I would assume, I'm not 100% sure what was actually proposed on the commercial lots, but if that's something where, you know,
If I could, Eric, I think the lighting ordinance requires full cutoff at a certain height anyway. It restricts to a certain height, I'm gonna say 20 or 25, without knowing the exact height of the lights. And it does require full cutoff. I think, if they would be agreeable to what Aristides somewhat touched on is the street lighting, which is required for any residential, streets. There is not very specific requirements on what type of lighting, but I think it is similar to a cutoff, and what you said.
dark sky.
Dark sky, I think that would kind of get to the idea of not having something visible from above.
I'm sorry, I didn't hear you. I didn't know.
I think Ms. B the streetlights, I'm sorry, the
Yes.
landscaping before you.
First off, no, my voice is good. But anyway, lights scare people that are bad. You know what I mean? Like drug use or all this kind of stuff that's gonna come back into the community. So the better you can light things up without people, being able to sleep, I, for one, would appreciate it.
Yeah.
The same way with landscaping. You're gonna have more pollution. So trees do what?
Clean air,
That's right.
amongst other things.
That's exactly right. So instead of taking away from our earth, put things back and add more things. Make it pretty.
Understood. I agree.
You can do it.
I agree.
All right, item 11.
Sure, 11, township may want to consider establishing the condition that the community landscape design plan, section 628K, include a landscape buffer screening for any residential use within the development adjacent to the active recreational open space areas. Acknowledged, and as indicated, as we develop the actual footprint or what's involved in those active recs, if the township wishes us to add additional buffers and it makes sense from the screening aspect, but maintaining safety. You know, if the family sends their kids out to an active rec and they want to maintain visual sightlines, there's a balance in there, but we have no qualms with adding buffers if requested.
Maybe for item 12, we'll reserve that comment for Mr. Mouse's testimony, and the same with 13. Item number 14, can you address the comment and then the revision on Plan 11 in response?
Sure. Comment 14, the location of any exit only onto Road B, which is the extension from Main Street through Hunter Hill. From what was indicated as a gas convenience lot does not appear to comply with the following requirements. A, site distance in accordance with section 416-25A6 from the stopped location of an exiting vehicle to the approaches of each lane at the intersections of Road A, extension of Willow Glen, and Road B. Road A, extension of Willow Glen, and Road B, I'll call it the extension of Hunter Hill. For that, we are, first, I'll go back to, because I think it came up in additional conversations, is that Exhibit A11 as presented tonight not only adds or shows the original landscaping plan back to that, but we've kind of re-evaluated that particular lot and to show it as a convenience store. We've removed the fuel pumps and whatnot. In regards to the site distance and safety of that particular intersection of roads A and B, we're looking at proposing a three-way stop. So the only, I'll say, uncontrolled vehicular traffic movement would be coming from 23 into the site, where Road A to the west, Road F to the east, and the continuation are coming south on proposed Road B would all be stop signs. So while it allows the movement off of 23 to prevent backups on 23, you have a more controlled intersection there.
So again, so the removal of the reference to the gas pumps addresses item number 14 as it related to
I don't know that's
maybe a comment earlier.
As far as the site distance goes, with the conditional use plan application, the plan submitted did not indicate stop signs at any point at that intersection. And looking at this, comment ways to mitigate and maintain traffic safety would be to add stop signs at 3 of those locations so that any potential cars exiting that commercial lot would not be dealing with constantly moving traffic. There would be another controlled intersection to the north.
So I'm sorry, Steve, I sort of jumped the gun a little bit there.
Okay.
On that comment number 15, can you address the comment?
Okay, sure. Comment 15, fuel pumps are permitted use in the IOP district, but are subject to the conditions listed in section 500-20B19. If the conditions cannot be satisfied, then the fuel pumps would require relief from the zoning hearing board. Understood that. Proposed configuration at this point on ours is conceptual. As indicated, there is a commercial developer, and they have consultants working through the detailed commercial development that would be occurring parallel to our plans for the residential portion. We shared Mr. Kraft's April 15th comment letter with the commercial developer and their engineers. As indicated a few minutes ago, the exhibit A11 that was provided, we showed the removal of the fuel pumps and referenced the gas station strictly as a convenience.
So that addresses the comment.
I believe so.
And the commercial developer wanted to use that required variance, they'd have to proceed through that procedure.
Correct.
Just to be clear, this, what you're asking the board to do now is to approve the conditional use plan as amended to permit a convenience store, or it would probably just fall under the category as a retail use, retail establishment at this point. So if there's going to be a proposal in the future to add fuel pumps or to convert it, you would need to come back for an amended conditional use at that point.
So that's what we need to do. That's, again, it could be.
If you get zoning relief one way or the other, then you would also then need to come back to amend plan. The plan that would get approved is not for fuel pumps.
Fair enough.
Is that everybody's understanding? Is that what you're proposing that we do here?
Very quick to respond to that.
So, the commercial was kind of a concept. I mean, if you remember, we showed a blank area there and then asked for us to show a concept, which is based on, the, businesses that are interested in locating there. Is that typically how it works, that you get conditional use and then get zoning relief afterwards? Or is what you're saying is you would get zoning relief? I just want to understand the process, because
What I typically see is zoning relief comes first. But again, if you're proposing a retail that does not require zoning relief, then that's what the conditional use would approve. The board would be approving a use that does not require any zoning relief. But if you then, a year from now, want to change the use to something different than what was approved, then amendment to the conditional use would need to be.
okay, if that's what you require, that's not what my experience has been in the past. It's a conditional use, and then you go seek zoning relief. But if that's what you require, we'll comply.
So I'm just making sure that we're on the same page with regard to what your future plans for that proposed lot is, so that.
In full candor, the discussions with interested parties is for a use that's going to require variance, but to eliminate that issue now, we'd like to move forward with conditional use, showing a use that's permitted by right, the convenience, general retail. That's all the conditional use approval would authorize. If somebody then decided to pursue variance and come back through the conditional use processes related to that particular lot, I don't see why we couldn't do that. Item number 16, we'll have Eric Mounts address that. Item number 17, 18, can we address 17, 18, 19?
Yes.
Sort of generally as acknowledge the comments.
Go Red Act 17, the street trees exist within the street right away on the side of the street where sidewalk is provided. It may be preference of township to move these outside of the right of way for consistency. We already kind of touched on that. We have no qualms acknowledged. 18, the plan shall include a note in reference to HOA agreement, covenants, and other document, including appropriate recording information for each. Will comply, acknowledged. 19, the declaration of building restrictions and covenants should include language to allow the applicable police departments to access the private streets for enforcement. Understood, acknowledged, that would be part of the agreements. And if that requires a note on the plan, we can add that as well. Want to go with 20?
Yeah, 20 is going to require a little more.
Sure. Comment 20, sidewalk and connection of Road B, again, that's Hunter Hill and Hunter Hill. In other words, our proposed dedicated road travels to the north of our property and ties into the existing Hunter Hill. We show sidewalk that is outside of the public right-of-way and it's proposed on private property, does not extend to the subject property boundary and is disjointed. All proposed sidewalks should provide a connection to existing sidewalk or crosswalks to the greatest extent feasible. We acknowledge that. I think in our particular plan, we overextended our proposed walk on the east side of Road B on the private property. Our intent would be to trim that back to the extent what we're permitted to construct. Similarly on the west side, I should note that the properties to the north of our property boundary, there are sidewalks, but they don't fully extend to our particular property, so there will be some disjoint unless, you know, we can extend it as much as we can and willing to do otherwise, but it would be on someone else's property, so.
Don't know what the right of way, Mike? Township can help with the solution to that comment. What do we do about connecting the property line, connecting the existing sidewalk that doesn't extend to the property line, you know, across private area? I don't know what we do about that, but we'll accommodate as best we can. And then item 21 is an acknowledgement of the conditional use process.
Correct.
I don't think I have any additional questions for Mr. Otero.
Board member questions?
I do. Hi, I'm Keith Fritz. And you covered this, but I'm a little bit confused. Going back to the open areas, storm facilities that are in the open areas, it's going to be the responsibility of the HOA, is that correct?
Correct.
And will there be any storm facilities? I'll use Highcroft. I know we have drains on people's properties that we have to get to, and piping that goes in there, so that they maintain that easement so that we can get in and out. Will that be the case there, or will all easements be under the sidewalk or out in the street?
Well, I believe we're required to have stormwater management easements around anything like those storm detention or retention facilities.
The reason I'm asking is because people like to put up fences, they like to put in sheds, they like to do things like that, which creates an issue for us. So if the HOA approves it and it doesn't come to us, then we can't regulate it, which is what my concern is, because we're dealing with that in various locations. So that's why I'm asking about the facilities and who's going to be responsible for them.
as part of the requirements, we have ownership and maintenance agreements that are required not only by township, by DEP, so those will be in place. And the easement itself permits township facility, or township staff, or its appointees to access should they need to.
It's sort of been in progression, obviously, first would be for the, HOA to do whatever it needs to do to maintain those facilities, but the township has joint authorities.
I'm sorry, John.
But the township basically has joint authority, it can access if the HOA fails to.
Yeah, the general easement is the township has the right, but not responsibility to access, so. Access and maintain.
Yeah, Gary, like to offer a vision.
I know what Mr. Fritz is referring to. The difference at Hycroft is, I think the township is responsible for all the stormwater. In our proposed community, the HOA is going to be responsible for the stormwater just about everywhere except the roads that are dedicated. And probably knowing how associations are managed, they'll probably police the easements better than, I'm not saying better than you folks, but they'll be looking at it on a more regular basis. And it will be their responsibility. The other thing on the maintenance, and we probably didn't touch on this, we're gonna write into the documents that the inspections have to meet the MS4 requirements. So they can hand over their inspections as part of the yearly reporting that you have to do as an MS4 township. But I know what you're speaking of, and I think that it's not gonna be a township problem because the HOA will police it.
And I'm fine with that. And I just want to verify, the HOA will take care of all open space. We're not going to be responsible for mowing or anything like that.
That is correct.
Okay, thank you.
I got one question. I see on the drawing that you it had 44 off-street parking, which is good, right? But you do have the garage parking, which is good, the driveway parking. The houses were set backward, because I have a crew cab pickup truck, and before I wouldn't even be able to park in the garage or the driveway. You did offset the houses?
Correct, yeah, I think, I don't know how long ago that was when we were talking about.
I just wanna make sure that's done.
Garages and the fact that sometimes those are occupied and not used for vehicles and the larger size trucks. I think Mr. Whiteman Jr. brought that up as well, in discussions, and we did push, the side or face of those homes back far so that there was, I think, a minimum of 21 feet between face of garage and the driveway to, the backside of the sidewalks.
Very good, thank you.
I had a couple questions here. We spoke about comment number 3 in the letter was, it referenced the rear front or side yards, specifically in that case, I included the townhomes. You had said they've been included in the calculations, but they weren't physical lines or weren't shown on the plans, correct?
Right.
There's several tables on the plans that have reductions and how these calculations came to. Does that need to be updated, or does that include that reduction?
I believe that's already been factored into these tables.
So
That had been discussed during our alternate process, plan revisions.
And if that, you could add that as a line, then specifically to show.
We need to outline that specifically.
Specified. Was there, infiltration testing done on the properties today?
Yes,
Did that include the commercial properties as well?
yes.
And the reason I ask is the discussion was about, the subsurface drainage and basically being, beneath probably the parking areas. And the question was, has it been determined that it is feasible to do that in those areas?
So, the infiltration testing was probably just for surface to surface, without knowing any potential proposed depths of those, underground facilities. Additional testing would need to be done at proposed depths and beneath that. Whether it's 2 to 4, 3 to 7 feet below, to indicate at those particular elevations what the infiltration rates are or feasibility of that is. I can say that the areas shown for surface facilities throughout our conditional use plan have been tested. While they're favorable on the east side, they're less favorable on the northwest side, northwest corner, which is why I think if you heard me earlier relay that will likely need to be more of an MRC type basin. Familiar with those. But in regards to final infiltration testing, we'll likely have some additional testing needed throughout the residential portion. And if we have to do retesting elsewhere, we can do that.
Part of the question was just if it did have to be a subsurface stormwater, since there wasn't stormwater shown on those lots. And as you said before, there's not much of a topography change on those lots. It's relatively flat. There's still an outlet for those lots if everything is going to be subsurface.
Yes.
Okay. And two other ones real quick. There was the discussion on Road A that the northern portion of that was going to be either burned or landscaped along where the trail is shown today. I believe the ordinance requires a commercial property against a residential property needs to have additional buffering to be met. I think that's the intent of this plan.
Correct.
But would you be agreeable, even though there's a public road to be dedicated, to consider that an adjacent property so that it doesn't meet those requirements? Mainly for the glare and cars in and out of the parking lots and through there, to be properly screened from those commercial lots by that.
On the north side of the road. Yeah, I think in his, and I'm sorry, I forget your name, but, there's a fine balance between maintaining that screening and public safety. So there's some things we need to consider. There might be the open pockets that are less screened at intersections or pedestrian crossings, but the intent is to adequately buffer the residential from the commercial with intensive landscaping and mounding of earth. So we don't have no problems with that. That's the intent.
Okay, and just two quick, same road, just to make sure we clarify that the initial plan that had been reviewed prior to this plan being submitted for conditional use, Road A, the extension of Willow Glen, was a 33-foot road, with sidewalk on the south side towards the commercial lots, correct? Originally.
That was years ago.
It really was. I believe so. I don't have that plan in front of me.
And I believe it was, but just so that the supervisor is aware that that road was widened to provide a turning lane, which still meets the minimum 33-foot width for the ordinance, for providing that, that sidewalk on the south side isn't shown. But the reason was to provide that turning lane along Road A where the commercial properties are, and allow for, less congestion of traffic traveling that road, but also provide a place for turns either to the residential area or the commercial area. Just to clarify, it's corrected by that change made.
Correct.
That was all I had to touch on a little bit.
Are there any other questions from Mr. Otero or Mr. Mounts?
And the break.
Good, hold on. Figure how to stop it.
You're finished, right, huh?